Hello, my name is Paul King, and I'm a district court judge in Douglas County. My assigned topic today is to discuss post-conviction motions made pursuant to Rules 32D, 35A, 35B, and 35C of the Colorado Rules of Criminal Procedure. I will be addressing the rules in that order. After I talk about each specific rule, I'll talk briefly about some practical considerations you may want to use when addressing motions filed pursuant to these rules. Rule 32D, withdrawal of guilty plea. This rule permits a defendant to withdraw a plea of guilty or nolo contendere, but only before sentence is imposed. For this request to have any vitality, it must be made prior to sentencing. There is no right to withdraw a plea of guilty or nolo contendere, and the matter is left to the sound discretion of the trial court. There must be a fair and just reason to permit the withdrawal of a previously tendered plea of guilty. Factors for the trial court to consider include the following. Will justice be subverted by a denial of the request to withdraw? Was the original plea entered into involuntarily or as a result of fraud or official misrepresentation? Examples of a trial court properly permitting a plea to be withdrawn include the following. 1. When the trial court has rejected a disposition. 2. When the defendant was improperly advised at the time the plea was taken. This is particularly so with respect to an improper advisement of the possible sentence to be imposed. 3. Immigration consequences were not discussed with the defendant prior to the plea. Examples of a trial court properly rejecting a motion to withdraw a plea include the following. 1. The defendant's expectation of a deferred judgment and sentence was a wish and a hope. 2. If the defendant's claims of sentence misapprehension were directly contradicted by the testimony of his plea counsel. 3. The defendant was intoxicated at the time of the plea, but the trial court determined that the defendant had the mental capacity to understand the entry of the plea. Practical considerations. 1. This motion must be made prior to sentencing. 2. You are not required to conduct a hearing on a 32D motion. It would appear that you can deny the motion without a hearing if the motion does not state sufficient grounds. 3. If the motion states adequate grounds, or if it raises issues or claims that need to be developed, you can certainly direct that a hearing be scheduled. This might be helpful when the defendant is claiming he received inadequate or ineffective representation by counsel, or the claims of the defendant relate to advice given him by his plea attorney. Rule 35A, correcting an unauthorized sentence. This rule permits the court to correct a sentence that was not authorized by law, imposed without jurisdiction, or imposed in an unlawful manner. The court can correct an illegal sentence or a sentence imposed without jurisdiction at any time. The court can only correct a sentence imposed in an illegal manner if the request is made within 126 days of the sentence being imposed. The court has a right and a duty to correct any sentence that was not authorized by law or imposed without jurisdiction. Practical considerations. 1. If a defendant makes this request and there is no objection by the prosecution, you may rule on this request without a hearing. 2. There may be ministerial functions, such as amending a minimus to reflect a period of parole, that can be done without a hearing. 3. If the people file a request, a hearing should be conducted before the trial court takes any action unless the defendant agrees to the change. Rule 35B, reconsidering or reducing a sentence. This rule permits the trial court to reduce a sentence upon motion filed by the defendant. A motion for sentence reduction or reconsideration must be made within 126 days of the date sentence was imposed, or within 126 days after the mandate from the appellate court affirming the sentence was issued, or after a final order denying appellate review. It is important to note that a trial court can deny a motion for sentence reduction or reconsideration without a hearing and without making detailed specific findings. This rule gives the trial court an opportunity to reconsider, in the interest of justice, a previously imposed sentence. The trial court can consider all relevant and material factors, including new evidence, in addressing a motion to reconsider. A motion to reduce or reconsider sentence is addressed to the sound discretion of the trial court. Absent an abuse of this discretion, the decision of a trial court on a motion to reconsider will not be reversed by an appellate court. Any delay between the filing of such a motion and requesting relief on the motion in order to establish a record of good behavior is not permitted. In fact, the burden of going forward on the motion is on the defendant. Here are some practical considerations for you. First, the trial court should first determine if the motion was timely filed. If not, the motion can be denied on those grounds. Second, if the original sentence was a stipulated sentence, the court does not have the ability to reduce or modify that sentence without the agreement of the district attorney. Third, the court can deny a motion for sentence reduction without conducting a hearing. If you do so, it would probably be beneficial if you were to refer to the original sentence and the matters that were considered by the court at that time. It originally imposed the sentence, to include the pre-sentence investigative report, the defendant's criminal record, statements of the victim and/or the defendant. Fourth, please be mindful of the Victim's Bill of Rights when reviewing any request for sentence reconsideration. There may be a requirement that a hearing must be conducted in order to obtain victim input before any reconsideration is granted. 5. Please keep in mind that any reconsideration of a mandatory sentence imposed for a crime of violence must be reported to the state court administrator pursuant to section 18-1.3-4061A. This is so even if the reduced sentence still falls within the aggravated range. And finally, please keep in mind that reconsidering a sentence may reopen matters that witnesses, victims, and other people thought were closed at the time sentence was originally imposed. And finally, Rule 35C, post-conviction review. This rule permits a defendant to seek post-conviction review. A defendant is entitled, as a matter of right, to seek such a review even though no appeal was sought or if the conviction was affirmed on appeal. There are 6 grounds for asserting post-conviction review. They are as follows. 1. That the conviction was obtained or sentence imposed in violation of the Constitution or laws of the United States or the Constitution or laws of Colorado. 2. That the applicant was convicted under a statute that is in violation of the Constitution of the United States or the Constitution of Colorado, or that the conduct for which the applicant was prosecuted is constitutionally protected. 3. That the court rendering judgment was without jurisdiction over the person of the applicant or the subject matter. 4. That there exists evidence of material facts not theretofore presented and heard, which, by the exercise of reasonable diligence, could not have been known to or learned by the defendant or his attorney prior to the submission of the issues to the court or jury, and which requires vacation of the conviction or sentence in the interest of justice. 5. Any grounds otherwise properly the basis for collateral attack upon a criminal judgment. And 6. That the sentence imposed has been fully served or there's been an unlawful revocation of parole, probation, or conditional release. While I've listed these statutory grounds, by far and large, the most frequently cited ground for post-conviction relief is an allegation that the defendant received ineffective assistance of counsel. In order to prevail upon a claim of ineffective assistance of counsel, the defendant must establish the following. 1. Counsel's conduct was outside the wide range of professionally competent assistance, and 2. The defendant suffered prejudice as a result. Any motion for post-conviction relief must be filed within the time limits set forth in section 16-5-402, which typically is 3 years for a felony. By this I mean a defendant has 3 years from the date that he or she was sentenced, if there was no appeal, or 3 years from the date the time the appellate process concluded, by that I mean the issuance of a mandate, to file a motion for post-conviction relief. If the motion is untimely, the defendant must establish the existence of justifiable excuse or excusable neglect in the filing of the untimely motion that would permit the court to consider the untimely filed motion. After the motion has been filed, the court should determine whether the motion states adequate factual or legal grounds for relief. If it does not, the court can deny the motion without a hearing. However, the court should enter written findings of fact and conclusions of law in denying the motion. The court is required to complete its review within 63 days of the filing of the motion. If the court does not deny the motion, the court should serve a copy of the motion on the DA and on the Office of the Public Defender if the defendant has requested counsel. If the public defender determines there is no conflict and you appoint them, then the people can respond to the petition for post-conviction review and the public defender can submit a reply. The DA has no duty to submit a response unless ordered by the court. After receiving the response and reply, the court can either set the matter for hearing or rule on the pleadings. If ruling on the pleadings without a hearing, the court is required to enter written findings of fact and conclusions of law. If ruling after a hearing, the court may certainly enter oral findings of fact and conclusions of law. The court is required to enter these findings within 63 days of the hearing or provide notice of a date when the ruling will be issued. If the court does not deny the motion, the court should serve a copy of the motion on the DA and on the Office of the Public Defender if the defendant has requested counsel. If the public defender determines there is no conflict and you appoint them, then the people can respond to the petition for post-conviction review and the public defender can submit a reply. The DA has no duty to submit a response unless ordered by the court. After receiving the response and reply, the court can either set the matter for hearing or rule on the pleadings. If ruling on the pleadings is without a hearing, the court is required to enter written findings of fact and conclusions of law. If ruling after hearing, the court may enter oral findings of fact and conclusions of law. The court is required to enter these findings within 63 days of the hearing or provide notice of a date when the ruling will be issued. Here are some practical considerations. First, upon receiving a petition for post-conviction relief, the court should first check to see if it's timely filed, pursuant to Section 16(5)(402). Second, if it is untimely filed, it is the defendant's burden to establish justifiable excuse or excusable neglect. If the defendant fails to do this, you can deny the petition by finding that the defendant has failed to establish justifiable excuse or excusable neglect. 3. If the petition is timely filed, please review it to determine whether it states adequate factual or legal grounds for relief. You can deny a petition without a hearing if you find the motion, file, and record show that the defendant's allegations are without merit. You should issue a written ruling which contains findings and conclusions. This is to be done within 63 days of the filing of the motion unless you set a later date for completing the review. You are not precluded from setting additional dates for review. Please be aware that defendants, who may be incarcerated for lengthy time periods, watch that 63-day time period and can file complaints if you do not rule or provide another review date. 4. If the petition has merit, you may then provide a copy to the district attorney and request a response. 5. You should also provide a copy to the public defender if the defendant is asking for the appointment of counsel. However, many times the defendant is pro se and raising ineffective assistance arguments about his public defender. If there is a conflict, the public defender can advise you, and you can then appoint the Office of Alternate Defense Counsel to represent the defendant. 6. If you appoint counsel to represent the defendant, they can conduct an independent investigation of the merits of the request. If they determine that it has merit, you can then direct the district attorney to respond to the petition. Defendant's counsel would then have the opportunity to file a reply. 7. You can rule based on the petition, response, and reply, or you can require a hearing. 8. You can issue an oral or written ruling. Any ruling you issue must include findings of fact and conclusions of law. 9. Once again, this order is to be issued within 63 days of the hearing or by a date set by the court. 10. Please be aware that case law holds that a defendant is not entitled to successive petitions for post-conviction relief. Thank you for your attention. If you wish to contact me on these issues, you certainly can. I can be reached in Douglas County at 720-437-6160. Thank you.